This is an appeal in the matter of the King on application of Mostafa and the Secretary of State.
Mr. Biggs.
Yes, good morning, my lord, my lady, my lord. I appear on behalf of the appellant entry clearance officer, and then friend Mr. Malik is here on behalf of the respondents. Unless there are any preliminary questions or issues, I propose to jump straight in. In terms of a roadmap, what I have in mind is this. Firstly, I want to take the court to Appendix ROB, or representative of an overseas business, and go through some salient aspects of that. Secondly, I want to deal with the correct construction, paragraph ROB 8.2, which is central to the issues in this case. Thirdly, I want to then go through the grounds of appeal, and I'll deal with each of them in turn. And finally, and by way of a sweep up almost, I'll deal with some of the points made in the respondent's notice. So, Appendix ROB begins at page 3 of the Bundle of Authorities. I'm sorry, I should have perhaps gone through housekeeping matters. There should be a hearing bundle and a bundle of authorities.
I think we've all had both of those.
Reached you, Lord, and thank you. So it's tab 1 of the authorities bundle, page 3 for those using electronic, the electronic bundle. The starting point is the introductory text on page 3, and the first paragraph under the heading Appendix Representative of an Overseas Business identifies the purpose of the route, albeit in a very compressed way. The next paragraph identifies, if you like, the nature of a representative of an overseas business. They must either be a sole representative or a media representative. In this case, we are dealing with a sole representative. And in the following paragraph, there is a definition of sole representative. And my ladies and my lords, you can read that passage. But of particular importance in it are the words establishing a branch. In this case, the sole representative, the first respondent, claimed to be a senior employee who is assigned to the United Kingdom for the purpose of establishing a branch of the overseas business. And establishing a branch we'll come back to. On page 5, paragraphs ROB 4.1 to 4.4, the appendix identifies work requirements. And of particular importance are paragraphs ROB 4.3 and ROB 4.4. ROB 4.3 makes it clear that the applicant must intend to work full-time as the representative of an overseas business and must not intend to undertake work for any other business or engage in their own business. So must work full-time, and the full-time employment of the representative of an overseas business must be exclusive. ROB 4.4, particularly A, is also highly important. It makes clear that a sole representative is a person assigned to the United Kingdom to establish and supervise a branch or subsidiary where that's relevant, where that branch or subsidiary will actively trade in the same type of business as the overseas business. So the idea, just taking stock of where we are at the moment, is that a sole representative comes to the United Kingdom in order to conduct the business of the overseas business in the United Kingdom and that has to be their exclusive occupation. Paragraph 5.2, ROB 5.2 towards the bottom of page 5 is also significant, as is 5.1, but no reliance was placed specifically on 5.1 in this case, so I'll just go over that. But ROB 5.2 is relied upon by the decision makers in this case. Decision maker must not have reasonable grounds to believe the business is being established in the UK by the overseas business, mainly so the applicant can apply for entry clearance or permission to stay. On page 6, the next page, we see this is probably the key rule for the purposes of this case. ROB 8.2, under the heading Additional Business Requirements for Sole Representative, etc. The applicant must be a senior employee of the overseas business with the skills, experience, and knowledge of the business necessary to undertake the role. Just to pause there, and I'll come back to this. The role is a person assigned to the United Kingdom for the purpose of establishing a branch, going back to that introductory text that we looked at a few moments ago. I'm not sure there's any dispute about that. We then see on page 9 details of the periods and condition of leave to enter that would be granted if the requirements in this appendix are met. ROB 11.1, granted a period not exceeding 3 years. So it's a substantial period of leave.
And it's a route to settlement.
Ungrateful load, yes, that's right. So those are the key aspects of Appendix ROB. We may need to come back to some of them. Certainly we need to come back to ROB 8.2, which is the topic I'll now deal with. So on the correct construction of ROB 8.2, the first point I just want to remind the court of, the first points I want to remind the court of, are the salient legal principles in respect of the interpretation of the immigration rules. The court will be very familiar with these, so unless the court wants me to spend more time on them, I propose to deal with them very quickly. The Supreme Court in the Wang case, that's at tab 4 of the authorities bundle, recently reconfirmed the correct approach. The relevant passages are paragraphs 29 to 31 on page 179. I'm sorry, my note's incorrect. It's page 156. Paragraphs 29 to 31. Paragraph 29 refers to the statement of Lord Brown in Mahad. We also have Mahad. I think give the court the reference. I don't propose to take the court to it in case my lords, my lady want to look at it. It's paragraph 10 of Mahad at page 410, the authorities, if you want to look at that. And at paragraph 31, page 157, going in Wang, the Supreme Court clarified that the applicable principles of interpretation when interpreting the immigration rules are not substantially different from those which apply generally in respect of legislation, albeit perhaps that there might be some degree of softening of strictness. So that sweeps in, if you like, the general principles in respect of the interpretation of statutory provisions. And on those, I have included two authorities in the bundle. The PACCAR case, which is at tab 2, page 22, and the O case, or Project for the Registration of Children's British Citizens case, which is at tab 5. Now, I only propose in the course of oral argument to take my lords, my lady, to PACCAR, and to do so only very briefly. The relevant paragraphs are paragraphs 40 and following, on page 36 and following. All of this will be very familiar territory. But I would emphasise paragraph 41, beginning at the bottom of 36, page 36, and going over, for the Supreme Court's recognition, the purpose and scheme of legislation provide the basic frame of orientation when interpreting the language used in it. And in a moment, I will make the point that the scheme of Appendix ROB strongly supports the Secretary of State's construction of ROB 8.2. Paragraph 43 on page 37 is another passage I would emphasise. Here, the Supreme Court explains the concept of absurdity and acknowledges that it has a fairly broad ambit, albeit that there are limits. And we do say that that principle may have some resonance in this case too. So the end point of the Mahad or Wang approach, together with relevant principles of statutory interpretation, is this: the court should sensibly interpret the actual words used in the immigration rules, but must do so having regard to the context, including the overall scheme of the rules and the purpose of the rules. And the court should also, where this is relevant, avoid an absurd construction, in the sense of absurdity explained in paragraph 43 in PACCAR. So our overarching point in respect of the correct approach and construction to ROB 8.2 is that the meaning of the rule is clear when considered sensibly in context, and it should be applied by a decision maker who has to adopt an evaluative judgment in the light of the clear and ordinary language used in the rule. But given the judgment of the Upper Tribunal below, it is necessary for me to deal with three aspects of ROB 8.2, which we say the Upper Tribunal got wrong. So the first of those aspects is the meaning of the words "the role" in ROB 8.2. And it may be helpful if we just go back to the text of ROB 8.2 on page 6 of the authorities. Applicant must be a senior employee of an overseas business with, so that's, as the Upper Tribunal correctly acknowledged below, that's, if you like, the first aspect of ROB 8.2. Applicant must be a senior employee of the overseas business. And then we get to the second aspect of ROB 8.2, which is what this appeal is all about. The skills, with the skills, experience and knowledge of the business necessary to undertake the role, and I'm focusing at the moment on the role. And then the third aspect of ROB 8.2 requires that the person has full authority to negotiate and take operational decisions on behalf of the overseas business. And as I explained earlier, the role, in respect of that second aspect of ROB 8.2, is the role of establishing a branch. of the overseas business in the United Kingdom, in this case, in the light of the introductory text, the appendix that we looked at. That begs the question, what does establishing a branch mean? And we say that establishing a branch is effectively synonymous with opening and supervising the branch. And supervising is synonymous with running. Now, in this case, my learned friend submitted to the Upper Tribunal below that the decision maker, in using the words open and run in the decision making challenged, had read words in to ROB 8.2 that were not there. We submit that that's simply wrong, because establishing a branch is synonymous with opening and running or opening and supervising.
Can we just talk around that for a moment?
Of course.
Suppose someone comes along and says, look, I'm not meant to stay there beyond the point at which the branch is opened. It's going to take a lot of work to organise things so that that there is a branch that can then run. Actually, I've done this around the world previously. I've gone from country to country setting up branches. I'm not meant to stay there. I'm meant to recruit management who will then take over. Can such a person obtain leave under this?
No, not in my submission.
Because they wouldn't satisfy 4.4 subparagraph A.
Exactly. That's the most straightforward point. But they also will struggle to satisfy 4.3 as well.
So just to understand, the 4.4a assigned to establish and supervise a branch where the branch will actively trade.
Yes.
So on your case, the supervise adds something to establish, does it?
My case is that the word supervised and the text more broadly, 4.4a and indeed 4.43, informs the meaning of the word establishing in the opening text of Appendix ROB, because that's part of the overall scheme of the rules in the proper context.
Because A talks about establish and supervising the branch where that branch will actively trade.
Exactly. That's right. That's exactly right, lady. And that's the point I'm just coming on to.
Oh, sorry. I'm so sorry.
No,
Well,
not at all.
it's my fault
really
for
helpful.
taking
You've
you
spotted it
as a
already. The reality is that the Upper Tribunal's construction of establishing, and my learned friend's case by reference to that construction of establishing, is simply inconsistent with in particular, Rule 4.4a. Because not only does Rule 4.4a require that the representative supervises the branch, and read in the context of 4.3, that means supervises the branch full time, and read in the context of the period of grant, that's supervised full time for 3 years.
Well, is that necessarily right? Because the grant is for a period not exceeding 3 years. I mean, if someone comes and says, look, I'm not meant to be there for more than a year, that's how long it's going to take to investigate the market and set up the branch. Is it fatal that ROB 11.1 talks about a period not exceeding 3 years?
It's a contextual indicator.
Yes, I see.
So not only is the word supervise important, particularly when read in the context of 4.3 and the period of the maximum period of leave, but also the words where the branch or subsidiary will actively trade in the same type of business as the overseas business. Those words are absolutely crucial in my respectful submission, because what they make pellucid is that establishing the branch means trading in the United Kingdom, pursuing the business of the overseas business. And that, we submit, is entirely consistent with the purpose of ROB, which we've identified at paragraph 27, my skeleton argument. you have that. You don't have that separately. That's at page 206 of the hearing document. So there we identify the purpose of Appendix ROB in the last sentence of paragraph 27 as being to help facilitate an overseas business gaining access to and thereby contributing to UK markets and the UK economy. Now, to some extent, turning up and establishing a branch and then going home might be consistent with that purpose, but looked at in the context of ROB 4.3, 4.4 and the overall scheme of the rules, that's clearly not what establishing is seeking to provide for. Now, my learned friend against me on this point relied below on the terms of a completely different immigration law, paragraph 245D. Now, very helpfully, my learned friend has brought along copies of that law if the court wants to look at it. I don't propose to show it to the court unless the court wants to see it. Our submission on that point is set out at paragraph 29 of the skeleton argument. The short point there is that in respect of that rule, it makes sense to use the word run in addition to the word establishing or establish, because that rule covers extensions of leave. So the process of establishing is an ongoing process which under ROB, Appendix ROB, envisages trading, but there will come a point at which the business is already an established business, and that point would normally be reached at the point that you are applying for further leave in order to continue your time in the UK to work for that business. And that's the context against which paragraph 245D and its use of the word run, together with establish, needs to be considered. The second point of interpretation in respect of ROB 8.2 that I should deal with in the light of the Upper Tribunal's decision is the suggestion by the Upper Tribunal that the role of establishing a branch can be short-term. Now, to some degree, this is not a particularly important point, but in my submission, as a matter of generality at least, the role of establishing a branch is not intended to be a short-term role. It would, we submit, be absurd to suggest that a person, a representative of an overseas business, could come to the United Kingdom only, if you like, to cut the ribbon on a branch. And it needs to be borne in mind that that is not, that short-term purpose is really not consistent with the nature of the respondents' applications in this case. The respondents were seeking to relocate their entire family to the United Kingdom. The first respondent was the overseas, was the representative of the overseas business, purported to be. But the other respondents are her husband and children. And so they were seeking to relocate for a semi-permanent purpose for an extended period, no doubt assuming that they'd be granted around 3 years of leave. So to suggest in all cases that establishing a branch is a short-term enterprise is, in my submission, to misunderstand the nature of Appendix ROB and the concept of establishing that it uses. The third point of interpretation that I need to deal with in respect of ROB 8.2 concerns the words skills, experience and knowledge of the business necessary to undertake the role. So if we go back to the text of ROB 8.2 on page 6, you'll see this is what I've and the Upper Tribunal have characterised as the second aspect of ROB 8.2. And the Upper Tribunal, we'll come to the Upper Tribunal's decision shortly, adopted a narrow view of what skills, experience and knowledge of the business could encompass. We submit that the words skills, knowledge and experience of the business concern the skills, knowledge and experience of the business to be undertaken in the United Kingdom, it being clear from paragraph ROB 4.4 that the business that is to be done pursuant to the branch being opened or established in the United Kingdom is the same business as the overseas business undertakes outside the United Kingdom. So it's the knowledge, skills and experience relevant to the business to be undertaken in the United Kingdom that this second aspect of ROB 8.2 is concerned with.
Supported by the last bit of 8.2 with full authority to negotiate and take operational decisions on behalf of the
I respectfully entirely agree with Lady. I have segmented ROB 8.2 into those three aspects, but of course ROB 8.2 needs to be interpreted in context.
Yeah.
And the immediate context is the other, are aspects 1 and 3, if you like, of the rules. So what we submit that what that means is that the applicant can properly be expected to have knowledge of the UK market that the business is seeking to enter. Because that's clearly covered by or encompassed by the words skills, knowledge and experience of the business to be, I say, the business to be undertaken in the United Kingdom. But secondly, and more broadly, those words encompass knowledge of those things that are needed to establish a viable branch of the business in the United Kingdom. And those things would include, for example, 1, a person's involvement in producing the business plan for the UK branch. It could also include their knowledge of the business plan more broadly, but the fact that they might have been involved in producing the business plan is relevant. Secondly, the pricing of goods and services to be sold in the United Kingdom market. Thirdly, the plan for recruitment of staff to the UK branch. And fourthly, at least potentially, an understanding of the geographical location of the United Kingdom, given the choice of the UK rather than, in this case, mainland European countries, to establish the branch. So, my lords, my lady, those are the points that I wanted to deal with in terms of ROB 8.2. Unless the court has any questions in respect of those 3 points, I will move now to deal with the grounds of appeal. I think it's convenient to take grounds 1 and 2 together. On analysis, really they are 2 sides of the same coin. Ground 1 deals with what we say is the Upper Tribunal's erroneous interpretation of ROB 8.2, and ground 2 deals with what we say is the Upper Tribunal's erroneous interpretation of the word establishing, or the words establishing a branch in the introductory text of our appendix ROB. But on analysis, those words inform the meaning of the words the role in ROB 8.2. And so grounds 1 and 2 really can be taken together, I respectfully suggest. The Upper Tribunal's decision begins at page 28 and following of the hearing bundle. And in the interests of time and I hope efficiency, I'm not going to go through all of this decision exhaustively. I'll focus just on those aspects of it that are particularly relevant to grounds 1 and 2 at this stage. At paragraph 43 on page 39, the Upper Tribunal considered ROB 4.3 and 4.4 and rejected the argument by reference to ROB 4.4 that the word supervise in ROB 4.4 and the other terms, the text of ROB 4.4a, meant that the word run could appropriately be used in this case to describe the role. The judge also suggested that ROB 8.2 did not necessarily import a requirement for working long term.
If that's right, why is it a route to settlement?
Indeed, my lady. As I hope have been clear earlier,
Yeah.
the length of leave, and also I respectfully endorse my lady's observation, the fact that this is a route to settlement.
Which is made clear right at the very beginning of the introductory text.
Indeed.
Last little bit of the introductory text.
I'm grateful. Thank you. Those are very strong contextual indicators to me that are inconsistent with the suggestion that ROB, Appendix ROB, if you like, allows for a short-term situation as a basis for a grant of leave. And the other contextual indicator there, my lady, is that it's possible to obtain extensions.
Yeah.
The next passage I would highlight for the purposes of our ground.
Sorry,
one,
I'm so sorry to interrupt, Mr. Biggs. Where from the text does one get the fact that one can apply for an extension of leave under these provisions?
So I can perhaps provide a better indication when I'm not on my feet. Just looking at ROB 8.5.
Yeah. Yes, I'm sorry to spring that.
No, not at all, my lady. I should have had it at my fingertips. ROB 8.5. Second clause, or was not last granted permission as a sole representative, makes it clear that you can get an extension. So I'm sorry, this is on page 7.
No, I haven't got page 7.
No, nor do I actually.
I've only just
I've got an
realised.
electronic version, but
Strangely enough, I do have page 7 in the hard copy. I don't know why there's a difference.
Yeah, no, I don't have page 7. All right, so page 7.
I'll look it on that.
I really don't
Yeah,
understand
I'll look
what's
it.
going
I mean,
on.
I've got the digital bundle. I haven't got my laptop here.
I'm grateful.
Okay, so it's page 7. Sorry, which paragraph again,
It
please?
says ROB 8.5,
ROB 8.5.
where the applicant does not have or was not last granted permission as a sole representative, the applicant must provide all of the following from their employer. And you see similar expression actually on in the preceding rule, ROB 8.4, which you should have in the electronic at the bottom of page 6.
And actually also 8.6, and has or was last granted.
That's the pattern that we see repeated, I think, from ROB 8.4.
And just to be clear, when it says in ROB 1.1 on page 3, a person applying for entry clearance or permission to stay, entry clearance you apply for from abroad. When it was, because the language has changed since I did a lot of this, but is permission to say the equivalent of leave to remain?
It is, my lady. There are specific definitions in paragraph 6.2 of the immigration rules, and permission to stay is defined in terms of leave to remain. So, as my lady implies, there's a distinction under the Immigration Act 71 between leave to enter and leave to remain.
Yeah. So that implies that you can, if you're in if you're in the United Kingdom, does it imply you could apply for leave to remain under these provisions if you're already in the UK?
Yes.
I just want to be absolutely clear.
Now, I
that
need
I've
to just
understood that
double check
correctly.
the possibility of switching from some different route.
Yes.
I think that probably was a possibility at the time, but I'll need to double check that. But certainly from the text we've just looked at, ROB 8.4, etc., it's possible that you were granted leave to enter under this route and then you're applying effectively for an extension.
Yeah. I think it's quite important. May, isn't it? That's not really focused, not at all.
Thank you, my lady. So, just going back to then the Upper Tribunal's judgment, the next paragraph I intended to refer to paragraph 47 and paragraph 48 on page 40, the hearing bundle. Paragraph 47 makes it clear that the Upper Tribunal has adopted an unduly narrow interpretation of that second aspect of ROB 8.2 that I spent some time explaining earlier. I think 10 lines up or so from the bottom of paragraph 47, you'll see the clearest indication of that. The sentence beginning, nothing in the rules indicates, sorry. Okay. Sorry, it's 9 lines up from the end of paragraph 47. The sentence, nothing in the rules indicates that the applicant should have knowledge of the UK market. There is no requirement for the applicant to remain in the UK to run the business. I think the word or should be stray, long term, having established the business. We say that shows that the Upper Tribunal went fundamentally wrong in interpreting ROB 8.2, and that error affected the Upper Tribunal's assessment of the issues.
Is the Upper Tribunal right in the last bit of paragraph 47? The suggestion appears to be that before the amendment in HC 1118, you couldn't apply to the extension for an extension of existing visa. What does that look like?
No, I'm not. With respect to the Upper Tribunal, I'm not sure what the sentence is simply not part of the law which applies. Is seeking to.
Because she seems to be suggesting that there's been a later amendment to these provisions, which makes it clear that you can apply for an extension.
No, well, that's if that's the suggestion, that's wrong. What the amendment that was made, that I think is probably what the judge may have had in mind, although I'm not sure how that would be relevant to the judge's reasoning, is that it's the route for entry clearance closed. I think with HC 1118.
Yeah.
So no new applications for leave to enter could be made, or entry clearance could be made.
Right.
But it was possible still to obtain leave to remain if, for example, you'd already been granted.
Which
if anything, I would suggest.
Which, if anything, suggests the opposite from the point that she's making.
Indeed. If anything, that would support our construction.
Yeah, absolutely. All right. Thank you.
And then we see in the last sentence of paragraph 47 a statement which, looked at in isolation, might not necessarily be objectionable. The reference to necessary in the rule is in relation to enough skills and knowledge of the business overseas to enable the applicant to establish a branch office in the UK. But looked at in context, what the judge seems to be saying is that you only look at knowledge of the overseas business. You don't look at business itself. And as I tried to explain earlier, what ROB 8.2 in terms of aspect 2 that I've been looking at is talking about by the word business, is the business to be undertaken in the United Kingdom. that must be right when you look at paragraph 4.4a. Appendix ROB. So there seems to be a failure to appreciate that business overseas also encompasses the business to be undertaken in the United Kingdom. We then see at paragraph 48.
Also, how can you establish a branch in the United Kingdom if you only know about the business overseas?
Indeed, my lady. But as we put it in the skeleton argument, I'm paraphrasing, but we say that just flies in the face of a common sense and contextual and proposed interpretation of these provisions. Paragraph 48. Deals with my own friend's reliance on paragraph 245D. I've dealt with that as well earlier. I think it's right to say that that provision does use the word expression, establish and run, but I've explained why the context of that rule makes that appropriate. So we say that on the points of construction raised by grounds 1 and 2, it's clear that the Upper Tribunal went wrong.
So just looking at paragraph 49, one sees in the last sentence the judge in the Upper Tribunal concluded that the ECO had made an error of law, obviously opening matters up. You say she herself was wrong in her interpretation.
I'm very grateful, my lord. Yes, I mean that's the sort of concluding point, if you like, to grounds 1 and 2. The Upper Tribunal's erroneous interpretation of ROB 8.2 led the Upper Tribunal to err by concluding, we say wrongly, that it was wrong for the decision makers in this case to use the expression open and run when asking whether the applicant had shown the required or necessary, required as a synonym for necessary, we say, skills, knowledge and experience of the business to be undertaken in the UK.
I can see there is a nuance of meaning between supervise and run, but yeah, she did a little Venn diagram, a bit of an overlap, wouldn't there?
Yes. In this context, we respectfully submit that there's not much logical space between supervise and run. I acknowledge that in principle one could find that logical space.
You can also then look at 4.3, work full time.
Indeed, my lord. So supervising the branch effect in being pragmatic about it and not being too, with respect, loyally about the language used. Run is synonymous with supervise.
Yeah,
in this context. And of course, we have to appreciate that these decision makers are not lawyers.
Sure.
They're trying to encapsulate in an accessible way what the rules require in the way they express their decision making in the decisions challenged in this case. So we say that grounds 1 and 2 are plainly well founded and wholly undermine, if you like, the edifice of reasoning deployed by the Upper Tribunal. I'll deal now, if I may, with ground 4, which challenges the judge's decision on 2 points that were raised below. Firstly, the question of procedural unfairness, and secondly, a reasons challenge. Dealing first with the procedural unfairness issue, we respectfully submit that standing back and looking at the process of decision making in this case, there was plainly no procedural unfairness. There is a clear and close analogy in respect to the decision making in this case to the decision making in a case called TAJ. The TAJ case is at tab 6, page 193 and following. Key factual background in the argument of the parties is set out at paragraphs 4 and following on page 195. this was an application made under, I think, the entrepreneurial, which was part of the points-based system. Appendix ROB is strictly not part of the points-based system, but in my submission there are some similarities between Appendix ROB and points-based rules. But in the TAJ case, although the application was covered by the points-based system, the basis for refusing the application required the application of an evaluative judgment in respect of non-points-based aspects of the relevant rules. And you can see that towards the end of paragraph 4. There were concerns about the viability and genuineness of the business, which led to the refusal. And then at paragraphs 5 to 6, you see a summary of the arguments that my learned friend made on behalf of the appellant in that case. And paragraph 7 sets out the Secretary of State's arguments. And at paragraph 51 and following, page 208 and following, this court rejected the appellant's argument for a number of reasons. I won't go through all of them. But perhaps particular salients are the points made at paragraph 55, bottom of page 209. The PBS is open and transparent. Well, so are the rules in this case. The claimant knew full well the evidence that needed to be provided and the relevance of each evidentiary matter to the test to be applied. Again, that's applicable here. Paragraph 56, top of page 210. Not unreasonable in circumstances to expect the burden of providing the information should lie with the applicant. If a series of inaccurate or incomplete pieces of information is tendered, responsibility fairly lies at the door of the applicant. Paragraph 57, perhaps less significant in the instant context because this isn't a points-based system context. But it is right to note that Appendix ROB sets out clear rules which are designed to aid decision makers and do, to some degree, reduce the scope of the need for evaluative judgments and flexibility, certainly flexibility. Paragraph 58. The claimant had every opportunity to prepare for the interview and to bring with them whatever information they chose. Again applied in this case. 59, the argument that there was some systemic unfairness was rejected, and that must be the case here too. And then at 61, there's an acknowledgement that decisions under the points-based system can lead to hard outcomes, but that's appropriate because of the nature of the points-based system. Again, we're not in the points-based system here, but there is at least some applicability of those observations in this case. Appendix ROB sets out clear requirements, and if those requirements are not met because an applicant doesn't provide adequate information, they know where they stand. Their application is going to be refused. So we say that the TAJ case is closely analogous to the instant case. And in TAJ, the Court of Appeal explained that there was a tripartite process. There was application, then an interview, then a site visit. In this case, there was an application and an interview. In TAJ, there were no specific points put in interview, as I understand it, alleging that there had been lies told, or that the business or that the entrepreneurial activity was not genuine. Now, in this case, my learned friend argues that, I think he argues, that the interviewer should have specifically put certain matters to the first respondent. That argument should fail in the same way that it failed in Taj. What matters, and I'll come to the interview in a moment, is that overall the process, including the interview, gave the first respondent a fair opportunity to put forward the basis of her application. And we say plainly, the first respondent had that fair opportunity.
The actual application, I don't think, is in the bundle.
No,
That's because neither side thinks it has.
That's right. I did anticipate a question about that. We can, I'm sure, produce the application, but the reason it's not there is that no one, certainly my own friend, doesn't think it helps. I don't see any significance to it, but of course, if you want to look at it, we'll...
No, I mean, if neither side. I think my colleagues want to look at the application.
I imagine you're both right that it doesn't really add anything. Maybe for completeness, it would be a good idea to send it through, or indeed, if it were available, if we're going after lunch, to provide it after lunch. But I don't know if that's possible.
Okay.
I suppose, Mr. Biggs, it might be that it links into an answer that the first respondent gave to question 9. I told you before our 6 main export based blah blah blah, and it may be that the reference to before is a reference to the written documentation.
Indeed, that's not a point that I can immediately answer, frankly, but it may be that sheds light on that answer. So I think that does take me to the interview. It's in 2 places in the bundle, but the clearest copy is at page 98 of the pagination bundle. Or the pagination, sorry. Now, in the interest of time, I'm not going to go through every question and answer. My lord and my lady will need to, with respect, look at this closely in full. My headline submission is that when you fairly consider this entire document, it's quite clear that the first respondent was asked relevant questions to do Appendix ROB. Relevant questions in particular to that second aspect of ROB 8.2. And thirdly, there was no inexplicable confusion between the entrepreneur route and the Appendix ROB route. Just dealing with that point now, there are a number of places in this interview record where the applicant is specifically asked about the overseas business representative route or requirements that are clearly contained within that route. See, for example, question 8 or row 8 on page 99. And questions like question 9 that talk about the business that the applicant intends to set up in the UK have to be read in the context of the nature of the application that was made. And as I've explained, the applicant is effectively responsible for setting up and pursuing the overseas business in the UK. And my learned friend relies, and the Upper Tribunal relies, upon the statement in the conclusion box on page 103 of the bundle. Which incorrectly refers to the question as to whether the first respondent is a genuine entrepreneur. My submission is plainly that is a slip. when one considers the interview record in full and fairly and in context of the application that was made, it's quite clear in my submission that there's been no confusion between the ROB requirements and the entrepreneur requirements.
But in any event, what matters is what the decision maker considered.
Yes. Well, ultimately, yes, certainly in terms of a substantive public law challenge, my lady, but I think in fairness to my learned friend, he says that this interview is procedurally unfair. And what the Upper Tribunal said about that, I'll come to in a moment, but the Upper Tribunal effectively concluded that there was no public law duty as a matter of procedural fairness to put certain things to this first respondent, but the interview process was procedurally unfair because the interviewer had asked questions about the wrong rules. And we say that's just not a sustainable interpretation of the interview transcript, or indeed, I mean, this conclusion I think was probably influenced by the judge's erroneous and unduly narrow interpretation of ROB 8.2. Because if the judge thought ROB 8.2 was as narrow as he seems to have thought, then a number of the questions here might, on the judge's understanding, not seem relevant. But we say that was a clear error.
So just to understand it for a moment, there's no reference to genuine entrepreneur in the refusal letter. So as you say, the complaint has to be that because the interviewer was thinking about genuine entrepreneur, the questions were framed wrongly. I mean, I suppose even if they had been thinking about genuine entrepreneur, if they had asked the right questions, it wouldn't actually matter.
Indeed. Yes, if you like, a subjective error doesn't matter if objectively there was a fair process. So that would be an answer too, actually, because the reality is, we say, looking at this interview overall, bearing in mind the reasoning in TAG, which is at least to some substantial degree analogous here, it's clear that the applicant, the first respondent, had a fair opportunity to put forward the basis for her application, and in particular to deal with ROB 8.2. So I think I should probably at this stage go to the Upper Tribunal's reasoning on procedural unfairness. Upper Tribunal's decision, as you know, begins at page 28 of the bundle. The key paragraphs in respect of procedural unfairness are paragraphs 51 and following, page 41. As I indicated, the judge in these passages accepts that there was no requirement to follow, if you like, a Balajagari process, a mind-to process, given the context. But despite that, the judge says, notwithstanding that, this is paragraph 54 and following, bottom of page 41, going over, the judge held that there was an unfair process for the reason that I mentioned earlier. The interviewer, the judge thought, has made a fundamental mistake about the nature of the route that the first respondent had applied for leave to enter under, and so didn't ask appropriate questions to give the first respondent a fair opportunity to address the requirements of Appendix ROB. I've made the point of it already, but that's just not a sustainable interpretation of the interview transcript, and seems to have been and that assessment seems to have been understandably influenced by the judge's erroneous interpretation of Appendix ROB, and in particular paragraph ROB 8.2. So we say there is no procedural unfairness in this case, and the judge's conclusion to the contrary is unsustainable for those reasons. The second aspect of the second ground of review for the Upper Tribunal was a reasons challenge. And now, if I may, I'll take the court to the decision making in this case. The key decision is the 15th of November 2022 refusal of entry clearance in respect of the first respondent. Again, that's in a couple of places in the bundle. The clearest copy is at page 104 and following. I suspect the court has spent some time looking at this already, so I'll be steered by the court. I don't propose to go through it minutely. But the short point here is that the decision maker identified particular answers in interview that they felt gave rise to clear concerns about whether the first respondent could satisfy the requirements in ROB 8.2, particularly that second aspect of ROB 8.2, the skills, experience, acceptance aspect. Those particular aspects of the interview that cause those concerns are set out. They cover the first respondent's involvement in producing the business plan, the first respondent's knowledge of pricing of goods and services to be sold in the UK, the first respondent's understanding of recruitment of staff in the UK branch, and latterly, the first respondent's understanding of the significance of the UK's geographical position, given the nature of the overseas business, which was an export business. It's not entirely clear all of the details there. And we then see on page 105 the decision maker's reasoning in the paragraph beginning when asked for basic information and the two following paragraphs. Now, in my submission, the reasoning in this decision is plainly adequate to satisfy the well-known legal requirements in terms of legally adequate reasoning. I don't propose to take the court to it unless the court will be assisted by that. But the relevant requirements are set out in the South Parks DC Importer No. 2 case, which paragraph 36 of that decision, which is at page 434 in the authorities. But we say on a correct understanding of ROB 8.2, this reasoning is perfectly rational and reasonable, and it's certainly intelligible, bearing in mind that the respondents have asked the reasons challenge, not a straightforward rationality challenge. For the avoidance of doubt, this is perfectly sustainable reasoning. Now, one of the specific points that Malone made below and the Upper Tribunal accepted was that the question about the geographical that led to an error in geography that's mentioned on page 105, just above the salient reasoning in the passage. You also asked where will you base your business in the UK? Oh, I'm sorry.
It's the last UN question paragraph, is it?
Lastly, yes, it's that.
Oh yes, I'm so sorry. I got lost. That's right. Yeah, you stated that UK is nearer to. That's the barrier. I'm afraid. The Upper Tribunal accepted the submission made by Malone and Friend that somehow the question that elicited that response was unclear, and its relevance, the answer to that question, the relevance of the answer to that question was doubtful, because the first respondent wasn't being quizzed about geographical knowledge. But as I submitted earlier, knowledge of the geographical location of the United Kingdom, bearing in mind the nature of the business that the first respondent was intending to do in the United Kingdom, was plainly relevant. It was certainly open to the decision maker to treat it as being relevant, which is the right legal analysis in my submission, given a proper understanding of the second aspect of ROB 8.2. So there was nothing irrational in respect of that decision, and there was no failure to set out legally adequate reasons. The decision also has to be read together with the administrative review decision of the 23rd of June 2023, which is on page, again it's in a couple of places, but the clearest copy is at page 113. And in the interest of time, I'm not going to go through this in any depth at all, but in my submission, the reasoning in this letter shows a conscientious and appropriate assessment of the points made in the application for administrative review. We have the grounds for administrative review at page 156, of the hearing Bible, if you want to look at them. And the decision maker properly rejected those arguments, giving clear and sustainable reasons. So the Upper Tribunal, with great respect, was wrong to accept that any aspect of my learned friend's second ground of review was valid.
Just as sorry to interrupt, Mr. Biggs, just as a matter of interest, it looks from the record of interview as though the first respondent didn't have an interpreter. Is that right? It's not entirely clear, but if either of you knows the answer to that question.
I think there was an interpreter. If you look at page 98,
Right.
the initials are given next to the box with the words interviewer's initials.
But not interpreters.
Oh, yes, that's what, yeah.
Interviewers' initials, different.
Yes. Sorry, I've misread that. Yes, we can.
And their interpreter's code actually underneath that.
Yeah.
Sorry, and it also says English. Language used English.
That exactly. I hadn't spot. I think the short point is no issue with I think, my lady, you're right. I
think my lord's read it much more carefully than I have.
And me, perhaps, on this
Only
point, forgive me. But yes, I shouldn't have perhaps been so combative, my lady. Forgive me. It looks as though this interview was conducted in English. My lady friend perhaps is able to clarify it. But the short point is that there doesn't seem to have been any issue with the communication of the interviewer to the first respondent and vice versa.
That's really helpful, thank you.
Just to get dealing with other irrelevant things, or maybe the first relevant thing, interview method VC Flubber, VC Skype, stroke phone. There seem to be several different methods of communication.
Yeah, we can clarify this.
But it's one or other of
The
those.
point is, it was a sort of screen-based interview, I think. But perhaps it was a telephone. If the court wants absolute clarity,
I don't
we'll
think
do our
that's
best to
Mr.
provide
Biggs.
it. Thank you very much, my lady, my lords. So that brings me, I think, unless there are any further questions, to ground 3. And I don't propose to spend very much time on this at all, because our central point in respect of ground 3, this is the ground that deals with ROB 5.2, is that the contention that there was a material public law error because there was no specific reasons addressing the requirements in ROB 5.2. Just to be clear about what ROB 5.2 requires, that's set out on page 5 of the, page 5 of the authorities Bible. Decision maker must not have reasonable grounds to believe that the business of being established in the UK may move so the applicant can apply for entry clearance. So the short point in respect of the argument that the absence of specific reasons addressing ROB 5.2 constituted a material public law error is that there can't be any materiality to that argument, because ROB 8.2 was on any view, for the reasons I've given, sustainably applied by the decision maker.
Or another way of putting it might be that it isn't the case that you can only refuse 5.2 satisfied. You can refuse for other reasons.
Yes, and it's not with respect, it's not a sort of discretionary can. It's a discretion. It's a mandatory must.
Yeah.
The applicant has to satisfy ROB 8.2 and couldn't for the reasons given in the decision making. So 5.2, if there was a flaw in respect of that aspect of the decision making, really doesn't matter, even applying the sort of inevitability, old-fashioned inevitability test.
Yeah.
But we do make the submission that actually the deployment of ROB 5.2 was rational and intelligible because of the way ROB 5.2 is expressed. The decision maker must not have reasonable grounds to believe, etc. And the submission is that in the light of the reasoning in respect of ROB 8.2 and the concerns about the applicant's lack of knowledge and skills, experience, etc., the decision maker did have reasonable grounds to believe that the business was being established mainly so the applicant could apply for entry clearance. And that's tolerably clear from the reasoning and the decisions.
Sorry, I got the wrong in the six. Because that's all that's left once you've examined whether or not the requirements are met and the failure to answer questions in a satisfactory way.
Yeah. So you're left with someone who doesn't seem to have the knowledge, skills, experience necessary to do what they're trying to do. That gives rise to the reasonable grounds to believe, etc. And you'll note the word must. Decision maker must not. So this is actually framed in terms of an obligation. The decision maker doesn't have any discretion here. They're compelled to deploy 5.2 where those reasonable grounds to believe arise. And we say that's what happened here.
And I see the point, but here there is more of a flavour of something reprehensible. Does that affect the procedural fairness point?
Not in my submission, no. There was more of a flavour of something reprehensible in the Taj case. In Taj, it had been specifically suggested that lies might have been told or there was a lack of honesty. And the court, I won't go back to Taj, but the court in Taj at paragraphs 63 and following, paragraph 63 and following, page 211 of the authorities, specifically rejected my own friend's argument in that case that because there was a flavour of reprehensible conduct, because it was suggested that falsehoods may have been told, for example, that something like a Baligari process had to be followed. And that approach, in my submission, should apply a fortiori in this case. It wasn't asserted in terms that the applicant is not genuine. If that was the case, then 5.1 would have been specifically deployed. Well, I think that's the answer to my observation. Finally, then, unless there are any further questions, just on the respondent's notice and sort of sweeping up, it's not clear to me exactly what points my own friend may make in respect to the respondent's notice, but I think I've covered all of the points that he could make anyway. I think it suggested that there was some procedural unfairness that supports the Upper Tribunal's decision. I've dealt with that. I think it suggested that there was an incorrect application of the entrepreneur criteria. I've dealt with that. And then there's a sort of broadly expressed suggestion that the Upper Tribunal should have accepted that there was some degree of unreasonableness or inadequate reasoning. I think I've covered those points too. So for all of those reasons, my lady and my lords, I would respectfully invite this court to allow the Entry Clearance Officer's appeal, set aside the Upper Tribunal's decision and substitute for it a decision dismissing the application for judicial review. Unless you have any questions of this speech.
I don't detect any more questions, so thank you very much, Mr. Biggs. Mr. Malik.
Lady, my lords, I'm afraid there are two documents that I need to hand up. The first is a part of the immigration rules that was referred to by the Upper Tribunal in its decision. It is right and proper for you, my lords, to have that document. The second document, my lord, is one that my learned friend handed me this morning shortly before the hearing. it is the Secretary of State's published guidance on this particular route. It is common ground between us that it is not appropriate for the court to use this document to construe the immigration rules. But it is right, in my respected submission, that you look at this document. It will assist you in relation to one of the points that was raised. So, subject to any observations, what I propose to do, Lady and Lords, is to address you first on grounds 1 and 2 together, the grounds that concern proper construction of the immigration rules, and I will then address you on grounds 3 and 4 together, the grounds that concern other public law challenges. So starting with grounds 1 and 2, in my respectful submission, the case that my learned friend advances is A, inconsistent with the language used in the immigration rules. B, is inconsistent with the purpose of Appendix ROB read as a whole and would lead to absurd consequences. And C, it is inconsistent with the immigration rules read as a whole. So what I will do, Lady and Lord, subject to any observations, is to take you to one authority that will assist you in relation to all 3 points, and I will then make brief submissions on these 3 points in turn. Now, the authority that I will take you to is one that my learned friend referred to in his opening submissions. This is the judgment of the Supreme Court in Mahad. It's tab 12 of the authorities bundle. This is the ultimate authority on the approach to proper construction of the immigration rules. The issue before the Supreme Court was about the proper construction of the maintenance provisions in the immigration rules. If you look at page 408 of the bundle, you will see the relevant maintenance provisions, essentially requiring certain applicants to demonstrate that there will be adequate accommodation and maintenance for them available in the United Kingdom. There was a conflict of authority. A constitution of this court had held that third-party sport was not permissible, and another constitution had held that third-party sport was permissible. And that was the context in which the Supreme Court gave this judgment. If you look at paragraph 10 of the judgment of Lord Brown, you will see that he referred to what was said in MO Nigeria. It's right at the end of page 410. So in construing the immigration rules, my lady, my lords, you will look at the language of the rule. The construction depends upon the language of the rule. So you'll start with the language of the rule. and you'll then construe it against the relevant background. But what that involves, lady my lords, is consideration of the immigration rules as a whole. So we'll not look at a particular rule in isolation, but you look at the scheme, you look at the immigration rules as a whole. And then if you look at the text that appears between letters B and C, the construction must be sensible, it should not lead to absurd consequences, and it must be consistent with the natural and ordinary meaning of the words used. Lord Brown then identified what, in my respective submission, is a helpful tool to construe the immigration rules. And this is the tool that I would respectfully invite my lady, my lords to utilize in this case. If you go to page 415 of the bundle, you will see paragraph 26. So I have shown you the rules that were in issue before the Supreme Court. At paragraph 26, Lord Brown referred to certain other parts of the immigration rules. Those rules made it clear that an applicant for entry clearance cannot rely on third-party support. And there are then the examples of those rules, and my lady, my lords will see that contrary to the rules that I've shown you, these rules actually expressly exclude third-party support. And if you then look at paragraph 27, you will see that the appellants argued that these are the kinds of provisions needed to prohibit reliance on third-party support, and that they are conspicuously lacking from Part 8 maintenance requirements. So it's entirely legitimate to compare and contrast the language used in different parts of the rules. Lord Brown endorses that categorically at paragraph 28 and said that I'm decidedly more impressed, this is just right at the end of page 415, by the comparison with parts 6 and 7. If the Secretary of State was intent on ruling out third-party support, then he could perfectly well have made that plain by using the same sort of language as in parts 6 and 7. So may I now turn to the 3 points that I outlined at the outset and invite you to consider those points in the light of this authority. So dealing first purely with the language that is used in the immigration rules. If you look at tab 1, my friend has taken you to the relevant rules. Page 3, paragraph 3. A sole representative is a senior employee of an overseas business who is assigned to the United Kingdom for the purpose of establishing a branch, nothing more than that. The word and running are conspicuously lacking, missing. So what my learned friend, in my respective submission, invites the court to do is to rewrite the immigration rules, to artificially insert words that are not there. If you then go to page 5, my learned friend took you to the work requirements for a representative of an overseas business. And my learned friend relied heavily on ROB 4.4. Now, there are 2 short points that I make about reliance on this particular provision. The first point is that this provision is of no relevance to this case and is not an issue. Milady, my lords, you have seen the entry clearance officer's decision. The entry clearance officer in that decision took no issue as to ROB 4.4. The entry clearance officer could have said, but did not say, that the work requirements are not met in that decision. The point was not taken in the decision. The entry clearance officer then had 4 opportunities to take the point. The first opportunity was in the administrative review decision. No point as to supervision or the work requirement was taken in the administrative review decision. Just for the note, the administrative review decision is at pages 167 to 168 of the bundle. The next opportunity for the Secretary of State to take the point was in the pre-action protocol stage. The pre-action protocol response is at pages 174 to 179 of the bundle. The Secretary of State the entry clearance officer took no point as to the work requirement or supervision requirement. The claim was filed. The next opportunity for the Secretary of State was to take the point in the summary grounds of defense, pages 88 to 95 of the bundle. Again, the point was not taken against the applicant. And finally, the opportunity was to take the point in the detailed grounds of defense. The point was not taken. The detailed grounds of defense are at pages 65 to 76. And when I will show you the Upper Tribunal's decision, I'll show you a particular part where the Upper Tribunal says that this isn't a case where a point about this provision is taken at all. So my first point about this is that this is, for that reason, of no relevance. The second point that I make, respectfully, is that Miller and Friends case, again, with respect, invites the court to rewrite this rule. The rule says, 4.4, a sole representative, ... assigned to the UK to establish and supervise a branch. Not run a branch, supervise a branch. The author of the immigration rules could have used the word and run, but decided not to use that word. It would not be consistent with the natural and ordinary meaning of the rules for this court to construe supervise as running. There is a fundamental difference, and I'll explain that difference when I'm on the second point, and I will answer the question that my lord raised as to whether it's possible for someone to enter the country, establish a branch, and then leave. You then consider ROB 5.2, the rule that the entry clearance officer relied upon. There is nothing in the rule that requires running of the business. Uh, 8.2 is at page 6. Again, there's nothing in the rule that requires running of the business. The requirement is to have full authority to negotiate and take operational decisions on behalf of the business. It is not to have full authority to take operational decisions on behalf of the overseas business and to operate a business as well, or to run the business.
That's Because the person's an employee, not somebody running his own business.
Lady, the point is that, well, this is a requirement for the applicant. The applicant is required to show, among other things, that she has full authority to negotiate and take operational decisions.
Yeah, as an employee of a business, as an employee of another entity.
Yes, yes, but the point, again, focusing at this point on the language of the rule, the language does not entail a requirement that the employee will operate the business as well, or will run the business as well in the UK.
So just before you develop things further, as I know you're going to, just going back to 4.4 for a moment, that, as you say, refers to establish and supervise the branch. Leave aside the question of whether supervise is the same as run.
Yes.
That seems to be postulating a situation where the branch is up and running and you are supervising it. Is that fair?
Yeah. Yes. So, my lord, it's an entirely fair question. So I think I have finished the first point that I wanted to make. So this really is my second point, and I'll address it now. But I'll just say that I've taken you to the language that is used in the rules, and what the court should not do is to insert the word running that does not exist. Now, just moving on and dealing with the question head on, and I can see clearly that is the question that is troubling the court. So Milord asked a question when Milord was making his submission that, well, is it possible for someone to come to the UK, open a branch, and then leave? Milord said no. And Milady made an observation, and again, I can see clearly that is the point that is troubling my lady as well, that this is a route that leads to settlement. So you're granted leave to remain for 3 years, and you'll then get indefinite leave to remain. And therefore, the idea, if I've understood the concern or the submission correctly, is that the person will just stay on in the UK, work for the branch, run the branch as well, and then qualify for settlement. Well, that with respect is not the case. Is not the case, and to construe the rule in that way, in my respectful submission, would defeat the purpose of this route. For many decades, my lords, representatives of overseas business have been coming to the UK in order to establish a branch. Sometimes they establish a branch and leave, return to their country, return to their job, and supervise the branch in the UK from abroad, from the principal place of business. Or at times they decide to relocate to UK and to settle. And this is what the scheme really is. Now, Milady asked a question as to where are the provisions relating to grant of further leave to remain in this route. And when you will look at those provisions, you will see that they would support the submission that I'm seeking to make. If you go to page 10 of the bundle, you will see eligibility requirements for settlement by an ROB. So this is where initial period of leave is given, and the person then qualifies, stays on, and qualifies for indefinite leave to remain. So the applicant must have spent 5 years in the UK with permission. That's the qualifying period requirement. There is a continuous residence requirement. But you then look at the work requirements for settlement. Page 11, ROB 16.1. Well, throughout the period in ROB 14.1, when you have the initial entry clearance, the overseas business must have been active in trading with its headquarters and principal place of business remaining outside the UK. But look at B. The applicant must have been employed. Now, this is the applicant who is applying for settlement after being given a period of residence, must have been employed and working full-time for the overseas business. Or, and then the alternative, that business's UK branch or subsidiary. So the rules clearly contemplate a situation where an ROB would come to the UK, establish a branch, return to their original job, to the original place of business, continue working for the overseas business, and supervise the branch from the home country. Yet they would qualify for indefinite leave to remain as long as they meet other requirements.
That's extraordinary.
I mean, that is the, in my respect submission, is the scheme of this rule. And to suggest that an ROB must not only come to the UK to establish a business, but then run the business as well. Yes.
I'm probably just saying I didn't understand. What about 15.1? What do you have to do to meet the continuous resident requirement?
Yes.
Does that mean you have to be here?
Yeah. So you'll see that if you look at, yes, 15.1, you must meet the continuous residence requirement in appendix continuous residence. There's a sort of separate appendix that allows absences from the UK in certain circumstances. And of course, we don't have that exhibit. That appendix here.
But do you, to meet that requirement, have to be predominantly in the UK?
Well, you got to have 5 years. You must have spent 5 years in the UK, but there are provisions for there are provisions that allow them, certain applicants, and if my lord needs assistance, then we'll get that for you. That allows certain applicants to spend, say, 6 months outside the UK, 6 months in the UK, or as long as the period of absences are less than a particular period of time that is permissible. There are provisions that allow you, if you're working abroad, to stay abroad, to work there as well. So there are these kind of different exceptions.
What I'm just thinking about is how far, given that requirement, one can really think in terms of somebody coming to this country, establishing the business, and then leaving and living abroad, but providing some supervision for the UK branch and still qualifying.
It's possible for them to qualify. For example, if they come and establish a branch, and then their absences are because of their employment commitments, their employment for an overseas business or a multinational company. Those are the sort of exceptions that can be deployed. Of course, this case isn't about continuity of residence, but what 16.1b tells us very clearly is that, well, irrespective of what the residence requirements are, the ROB is not required to work for the UK branch. They can, but they must be employed and working for the overseas business or the UK branch. So in my submission, the purpose of the scheme would be defeated by the idea that the court should import the word running in the immigration rules. And that really explains why the author of these rules, the Secretary of State, decided not to use the word "and running" in the earlier parts of the rules. So when my learned friend says that, well, the answer to my Lord's question is no, then my learned friends will have to grapple with the effect of this particular provision and explain why it contemplates someone who is employed not by the UK branch, who is working not for the UK branch, but for the overseas business to still qualify for settlement. So the proposed construction in my submission defeats the purpose of this rule. It leads to, in my respectful submission, to absurd consequences. Now, the facts of this case are a good example to test how the scheme works. There is no dispute, as the Upper Tribunal noted in the judgment, that the business itself is a massive business that is based in Bangladesh. It exports garments to, as the court knows, to Germany, France, UK, Italy, Spain, Netherlands, and their buyers are giant retailers like Marks and Spencer and River Island. What they are planning to do is to open a liaison office in the UK. So this person, the applicant, who has worked for them since 2015 as a marketing executive, to come to the UK to study the local market, to see how things work, to then report back to the company, to facilitate opening of a branch in the country, in this country. One cannot expect, in my respective submission, a marketing executive or manager in Bangladesh or India or Australia or America to have expert knowledge about UK markets. And one cannot expect them, in my respective submission, to be able to run a business in this country. That is not what this route is for. This route is for them to report back to their employers, to set up a company, to establish a branch that would then be run by the local employees with some supervision by this applicant. That's all. Nothing more than that.
So just to be clear, you're distinguishing between running and supervising.
Yes.
You would accept that the rules contemplate that an individual will have some role once the branch has been set up, albeit that it might be supervision rather than running.
Yes, 4.4. But of course, you have my primary point that where the decision maker has a concern about supervision, they can refuse the application under 4.4, saying that you don't meet the work requirements. The applicant would challenge that. But here, the refusal isn't under 4.4. And no issue as to that rule was taken. This case, in my submission, is all about proper construction of 8.2. Sorry, 8.4. My apologies. 5.2 and 8.2. And the opening words that appear at page 3. There's no reference to supervision in those paragraphs. But you have my second point that, well, if my lord, you take the view that the point is available to the decision maker and it is somehow relevant to look at 4.4, my submission is that supervision is certainly not running. And there is a difference between the two. You can supervise a business without running it. The business would be run by the local employees, local managers. You can supervise them from your country of origin, from Bangladesh or India or wherever the original business is based. Or you can supervise the business while you are in the UK, but you don't run the business. You don't run the business.
And yet you do have to work full-time as a representative.
No, you must intend to work full-time as a representative of the overseas business. So your intention, the intention of the applicant, my lord, is to work for the overseas business.
What about the representative bit?
Yes, as someone who is representing the overseas business in the UK, the rule could have said, but did not say, that you must intend to work you must intend to run the UK branch.
So let's leave out the running for a moment.
Yes.
If it's postulated that the individual will have a role once the branch is up and running, to use a dangerous word.
Yes.
Now, that role, you say, can be by way of supervision rather than running it.
Yes.
But were that role to be a full-time one,
Yes.
it has to be full-time supervision.
Not necessarily. The reason is this, that, well, this applicant is a marketing manager for the company in Bangladesh. After setting up the company, it is perfectly possible for the applicant, in my respectful submission, to, and indeed it is contemplated by the rules, to continue working for
You're about
the business.
16.1.
Yes, for the business on a full-time basis.
Yeah.
And that role may also entail supervising the branch that is established. There is, in my respectful submission, nothing novel about the submission that I'm making. This is how this route has operated for years and decades. That is why in my submission there really is no authority which suggests that an ROB is required to actually run the business in the UK. Just moving on then to my.
You won't get settlements unless you spent the last 5 years in the UK with permission as a representative, and you've got to meet the continuous residence requirements.
Yes.
That's 14.1.
That's
So
that.
I'm not really understanding how you can meet 14.1 and 15.1 if you're off in Bangladesh for any length of time.
Yeah, lady. I mean, if it assists, then I can certainly produce appendix continuous residence.
That might not.
Okay, and when you will see that appendix, you'll see that there are certain exceptions.
Right.
But I mean, of course, this case is not about those exceptions.
No, I understand that, but it's all part of the context.
Precisely, but there could be arguments both ways as to the proper construction of the continuous residence requirements, and these are, of course, distinct requirements, and of course, for the purposes of the argument, we are looking at the work requirement.
Yes.
Then finally, the immigration rules read as a whole. Now, what if the business abroad wants to set up a branch in the UK, and they want one of their employees to run the branch, to establish and run the business in the UK? This is not a route for them. there is an entirely different route that relates to establishing and running of businesses. That is the entrepreneur route. And I've handed out the relevant rules. So if a person or a business has cash, £200,000 at that point, and if they want to set up a business in the UK, to make the investment in the UK, this is the route that they would take. Now you will see that what the rules actually require. If you look at 245D, you'll see purpose of this route and meaning of business. This is where a business abroad or an individual abroad is setting up a business in the UK and running the business. They have to set up a business. If you look at 245DB, it could be sole trader, partnership, or company. And then they must invest in the business. They must have funds available. That is C. But if you look at the next page, this is the second page, it tells us what the investment means. Invested means funds have been invested into a business or businesses which the applicant is running as a self-employed or as a director. So when the Secretary of State wants to use the word running, well, she says so. And this is the reason why I took you to paragraphs 26 and 28 in Mahad. And then just read on those provisions. If you look at Roman 2, paragraph 3, investing in businesses other than those which the applicant is running as a self-employed or as a director. And 4, you have the word establishing as well. Any spending which is not directly for the purpose of establishing or running the applicant's own business. So why is it, I respectfully invite you to consider, the Secretary of State has not used the same language in ROB appendix.
And I understand that argument. Can I just understand the context again? Suppose you have a business abroad which wants to send somebody to set up the branch and to run it going into the future. Now, I think I understood you a moment ago to say that this might be the appropriate route. But is that right? Because it'll only be a person coming as a representative of the foreign business. Is that what this is concerned with?
No. So if there is a business abroad and they want to expand and want to establish a business in the UK, not merely a branch or a business in the form of a partnership with a local business, or if they want to set up a company and run the business from here, then this is the route for them.
But if you want to send your person to take forward your business here, and that person is not a director, that's not what you're dealing with here.
I think yes, that is perhaps yes. I mean that is. I'm not sure if I had said something different. This is.
You probably haven't.
I mean this is the point that I was seeking to make, that if someone wants to set up a business and run the business in the UK, then this is the route that they would take.
I follow. If an individual thinks I want to set up a business in the UK, you
Yes.
use this route.
Yes.
But if you're a company in Bangladesh that wants to set up a branch here, you surely don't use this route, even if you want the individual setting up the branch to stay there forever and ever.
Yeah. So if you want to set up a branch in the UK as in partnership with a local business, or as a new company that is distinct from the company in Bangladesh, and have your own products here and run your own business, then this is the route that applies. But if the intention is to merely have a liaison office or a branch that would effectively represent the overseas business, so here the idea was that they would essentially take the orders. The business in Bangladesh would do the manufacturing, and they would act as liaison. Then ROB is the route. But the point.
Sorry, just to keep you on this relevance a moment longer. I haven't probably absorbed the rules, but there's a reference to the applicant either being self-employed or acting as a director or a member of a partnership.
Yes.
And that's a requirement, is it?
That is the requirement, yes.
The applicant has to be at that level.
Yes. So, yes. So this applicant, if the intention is to come to the country and to run a business, then the applicant can apply under this provision, come to the UK, set up a company, become the director of the new company and run the company, or register as a sole trader, run the business, or enter into a partnership.
Yeah.
But the point, it's a fundamental point.
Your real point is, well, when the Secretary of State wants to use running,
That's
the
it.
Secretary of State uses running.
Yes. And you see the word in Roman 2 for establishing as well, establishing or running. Well, why not say the same in the provisions that I've shown you, establishing and running. Now then, if you look at page 3, this is page 112 of 1339, you'll see G, well, this is relevant to the second ground. The applicant must provide a business plan setting out the proposed business activities in the UK and how he expects to make his business succeed. So there should be no conflation between the two concepts. So if you're applying as an entrepreneur, you're then expected to have enough skills and knowledge to run a business successfully, to have a business plan. But you don't have a parallel requirement in Appendix ROB for obvious reason, which is that the purpose of that route is not to require an applicant to run the business. These are requirements for entry clearance. I mean, it's clear from 245 DB, not leave to remain. This is entry clearance when the applicant is seeking to come to the UK. But it's also relevant to see what happens to entrepreneurs, how they qualify for indefinite leave to remain, and how that is different from ROB route. If you look at 119, page 119 of 1339, this is the. And if you look at the heading, requirements for indefinite leave to remain, 245 DF. So these are the requirements that an applicant has to meet. And if you look at requirement F, the Secretary of State must be satisfied. A, the applicant has established the business, that is establishing the requirement, establishing of the business requirement. And then the applicant has invested the money in the business, and invested, we know from the part that I've shown you, means investment in a business that the applicant is running. And then 3, the applicant intends to continue operating one or more businesses in the UK. So ROB, instead of running, could have used the word operating as well, establishing and operating the branch. But there is no parallel requirement there.
So running and operate synonyms in this appendix. Because you've got the word running in 245 capital D.
Yes.
C, C, little Roman 2,
Yes.
And you've just been showing us that the word seems to be operating.
Yes. So, lady, the running part that appears in the part of the rules, lady, that you've just highlighted, is relevant to subparagraph F2, Roman 2, which says that the applicant has genuinely invested the money, and that refers back to the definition of invested,
Yes.
which refers to running.
So, yes, my point is the word running is used in that definition.
Yes,
And then the word operating is also used, for example, in 245 DB
Yes.
I, little Roman 1 and little Roman 3. And my question simply is, do they mean the same thing or do they mean something different? And if so, what's the difference? It looks to me superficially as though they mean the same thing.
Yes, I wouldn't disagree. I mean, if this appeal was about proper construction of words, running or operating, then one could have made an argument that, well, there is perhaps a difference between the two. But for the purposes of the point that I'm making, I'm content for the court to proceed on the basis that running and operating mean the same thing.
We're not making a decision about this appendix. I'm just trying to understand the contrast you're making between the language of this appendix and the language of appendix 9.
Lady, the point is that, well, yes, I mean, I'm content, lady, for you to proceed to test my argument on the basis that running and operating mean the same thing.
All right.
But neither running nor operating are the words that appear in Appendix ROB. And that is the point that I'm making, that where the Secretary of State intends to have a rule that requires an applicant to run or operate a business, this is the language that the decision maker uses. Now, can I then made my points, if I may then show you the Upper Tribunal's decision. The Upper Tribunal's decision, as you know, is page 28 of the appeal bundle. And the relevant discussion starts at page 37. Look at paragraph, just above paragraph 32, you'll see heading conclusions. Now, under that heading, if you look at paragraph 33 first, you'll see that there is no challenge about two matters. First, that this is an established business in garment manufacturing. It exports to Germany, France, Italy, Netherlands, and the UK. And the business wished to expand into exporting summer clothing in the UK. So no challenge to that fact. The judge then directs herself, in my submission, properly as to Mahad and Wang, the lead authorities on the subject. She starts by analyzing the language of the rule. And if you look at paragraph 37, the judge makes the point, firstly, about the language, that the word run is missing. And it would be wrong to insert a word artificially that is not there. 38, the judge draws a contrast between the media representative provision, which refers to long-term assignment, and notes that for an ROB, there is no requirement for a long-term assignment. Paragraph 41, the judge records another matter which is not in dispute, that this is a business that supplies to River Island, Marks and Spencer, and no dispute that this applicant is a senior employee and has been employed since 2015. Now you then, of course, the judge then comes to the work requirements, 4.4, the requirement that my learned friend highlights, and that really is at the heart of his case. So paragraph 43, paragraph 42, the judge refers to 4.3. There's no reference to running there. And if you look at paragraph 43, line 8, the judge notes that there is no issue about supervision in this case. Indeed, no reference was made to supervision within the decision. The decision maker, as I could have said, that, well, you don't meet the work requirements. I'm not satisfied that you will supervise the business, the UK branch. This is not what the decision maker said, and it's too late for the point to be taken. And then the judge says that, well, that particular provision, which is not an issue which the decision maker has not relied upon, cannot really alter the meaning, and that would not justify importing the word run elsewhere. That, in my submission, is right. The judge was right in both points she was seeking to make. First, that this isn't really relevant, it's not an issue. Second, it would not justify artificially inserting the word that is simply not there in the relevant provision. The judge then looks at 8.2, and what she said at 47, and in my respectful submission, is plainly correct. So my learned friend's case is that the rule require an applicant to establish a business and then run a business. That is not the case. The judge says, I don't think there is any dispute about it, that establishing means setting up, not running. And there is no requirement for an applicant to have expert market knowledge of the UK, because an applicant is not required to run the business on a long-term basis.
Can I just test it a moment? So suppose, for the sake of argument, that to qualify, you have to be coming to establish and supervise the business once it is up and running. Is it irrational for a decision maker, when deciding whether that requirement has been met, to take into account the fact that the applicant doesn't yet know anything about the British market?
No, it's not. It's not irrational. So it's. I mean, if the applicant knows nothing about the market, says nothing about it in the interview, in the application, that could justify refusal of an application under 4.4. But may I respectfully make two points. The first is one that I have made already,
Yes.
that in this case, the decision maker did not refuse the application under 4.4. Second, this isn't a case where the applicant said that I know nothing about the UK market. Full stop. The applicant said that the idea is for me to go to the UK, to study the UK market, to get the relevant information, pass it on to my directors, that would then assist them to establish a business.
But the key point is not so much rationality, it is that the decision maker made an error of law.
Yes.
Yeah.
The decision maker said categorically that I'm refusing your application because I'm not satisfied that you are able to establish and run, quote unquote, establish and run the business in the UK.
So the decision maker was applying the wrong legal test on your case.
Yes. So, so the judge quite properly looked at the language of the rule. The judge then looked at other provisions in this particular appendix. And then 48, the judge deployed the tool that Lord Brown deployed in Mahad and said that, well, I'm now comparing the language that is used in ROB appendix with paragraph 245D, the entrepreneur part that I've shown you, and says that, well, that appendix refers specifically to establishing and running a business. The focus is different. The Secretary of State has chosen not to write ROB rule in that form. Now, when the Secretary of State has chosen not to do so, in my submission, it would be wrong in principle for this court to insert that word. If the Secretary of State wants to change her policy, the practice that has lasted, said for many, many years, and say that, well, if you're coming here as an ROB, you must run the business. Well, all she has to do is to amend the rules and to have that condition in. But as the rule stands, there is no such condition. And for these reasons, in my respective submission, the ultimate decision that the Upper Tribunal made on construction was correct. And the Upper Tribunal made no error in holding that the Secretary of State erred in law, the entry claimants erred in law in refusing the application. Just for completeness, if I may take you to page 148, this is the entry claims officer's decision. You have seen that, but I'll simply highlight the part that is relevant for the purposes of this ground.
Yeah.
So after setting out many questions and answers, you'll see, of course, no reliance is placed on the work requirements under 4.4. And the conclusion is just above the heading administrative review, the second last paragraph under that heading. You do not meet the required skill or knowledge for this business to be able to open and run a new branch in the UK. The simple conclusion that the judge reached was that, well, that isn't the requirement in the rule. If the requirement is of supervision, then the application is not refused on that basis.
If the words had been, instead of open and run, establish and supervise, that would be unarguable.
No. Then the argument would have been that, well, you have referred to supervision here, but if you look at the earlier part of the decision, you made no reference to the work requirements. You have referred only to the genuineness requirement and additional requirements. So the decision maker will have to, in my respective submission, it's not simply about just replacing the word there. You'll see that there is no analysis, there's no reference to the work requirement, no analysis of what supervision actually entails. The application is refused quite clearly on the basis that the applicant will not run a business. That's the wrong test. And may I then just move to grounds 3 and 4? Yeah. These are other public law arguments. I'll address you very briefly on the law first, and then on the facts. First, on the adequacy of reasons. The authority is well known, of course, it's Porter, but I do want to take you to it because I want to make one particular point as to the test that this court would apply, or the test that the Upper Tribunal applied. So if you go to tab 13 of the bundle, you have a quota and the paragraph that is so well known is paragraph 36, which is at page 434. Of course, the reasons must be adequate. There is no question about it. But if you look at the text between D and E, line 6, the reasoning must not give rise to a substantial doubt as to whether the decision maker erred in law. Substantial doubt. So I need not to persuade the court, and there was no requirement on me to persuade the upper tribunal that the decision maker had definitely erred in law or the decision is irrational. As long as there is substantial doubt because of the reasoning that the decision maker has applied the wrong test, the claim succeeds. And this is really what the upper tribunal did. Said that there is substantial doubt as to whether the decision maker had erred in law.
But we do need to read the rest of that passage. So, Lord Brown gives a couple of examples. For example, a misunderstanding some relevant policy.
Yes.
This is the planning context.
Yes.
Or some other important matter, by failing to reach a rational decision on relevant grounds, but such an adverse inference will not readily be drawn.
Yes. But the test remains, in my submission, of substantial doubt for the purposes of this limb of the argument. So it's not the case that this aspect of the claim could only have succeeded if the judge had concluded that the decision is irrational, or the reasons are irrational, or there is certainly a public law error. If there is substantial doubt whether the decision maker applied the correct test, or whether the decision maker had right rules in their mind, the test would not be met. Then very quickly, two authorities on interviews. First is Mushtaq at behind tab 11. Interviews, as Lady Lords would know, are quite common in the immigration law jurisdiction. And Mushtaq conveniently summarizes the purpose of an interview. So Roman 2. The interview has a twofold purpose. The first is to probe and investigate. You probe and investigate. And second, you give the applicant a fair opportunity to respond to potentially adverse matters. Probe and investigate and give a fair opportunity to respond.
Doesn't that have to be read in light of the passage to which we were referred by Mr. Biggs? I think in Taj, which basically says that you've got a really detailed scheme of rules. The applicant knows jolly well what he or she's got to show.
Yeah. So yes, so I'll take you to Taj as well, where the finding. I mean, this isn't. I'm not making any Taj point. I mean, the challenge in Taj was that the points-based system is inherently unfair. There's no point as to that. The interview that was conducted in Taj was comprehensive. It was analysed in full by Lord Justice Green. The interview was fully fair. But this is a general point, which I expect, I hope is not controversial. The second authority is Anjum, tab 10. Roman 2, again a principle that this court can proceed on the basis of that if that the interview must be fair, it must meet the minimum requirements of fairness. And that may require repeating a question or to clarify obscure answer or probe or elucidate answers given. So if an answer is not clear, then there can be a duty to clarify and elucidate the answer. Then very quickly, Taj. This isn't a Taj territory case at all. I'm not making any of those points. But given that, Milady, you asked a question about Taj, may I ask you respectfully to look at paragraphs 13 to 16 of Lord Justice Green's judgment. You'll see this is page 199 of the bundle. There is a heading, the interview, above paragraph 198. In paragraph 13, Lord Justice Green says that, well, the questions in that case were comprehensive. There were 48 questions, and then you'll see that some of the questions were picked. A fair opportunity was given to the applicant to address the concerns that the decision maker had. But that, of course, case was about a tier 1 entrepreneur category. Now, there isn't really, in my special submission, a need for the court, for this court to look at, in order to decide grounds 3 and 4, to look at Taj, at Balaji Gari, at Pathan, or the other authorities that I've cited. The reason being that you have a document from the Secretary of State about this particular route. This is the Secretary of State's policy document. And may I take you to page 14 of this document? Again, this is not a document that can possibly assist the court in construing the relevant rules. That would not be permissible. But if you look at page 14, you'll see a heading, genuineness. You must be satisfied that the applicant is a genuine representative, that they intend to work for the business, and the job is not created mainly for the applicant to apply for entry clearance. But see the third paragraph. This is the Secretary of State's decision maker's policy. If you suspect the applicant is not genuine, which is the suspicion here, or complicit in taking the role as the overseas business representative primarily as a means to obtain permission in the UK, this case, you must put your concerns to the applicant in clear language and give them a chance to respond, either in an interview or in writing, before making a decision. You've got to tell the applicant that, well, I suspect that you're not a genuine applicant, you're complicit in this. That is my concern. What do you want to say about it? This is the requirement, consistent, in my respectful submission, with the case law. And this is the policy document that was applicable when the decision was taken. Now, with this in mind, can I?
On this in the Upper Tribunal.
No, lady, no. This was disclosed to us 5 minutes before the hearing this morning. Yeah, I'm very grateful to Mladen Friend for doing so. I mean, of course, he was being fair and transparent.
Presumably, is it available on the internet, or is it an internal document?
No, it is a published document. Yes. Yeah.
I don't want to interrupt my but I should just make sure we had always understood that my own friend and his clients were aware of this policy.
Yeah.
I just brought it along today because I thought the court might want to see it.
Yeah, lady, I mean, of course, the point, of course, was made before the Upper Tribunal. It's made before this court that the interview was unfair. But the reason I thought I would just show you this policy quickly is that it would save time rather than just looking at various authorities. You simply look at what the decision maker has publicly said about genuineness concerns. Lady, I would of course accept that, well, this does not apply to ROB 8.2. This only concerns ROB 5.2.
Are you moving on to the facts?
Yes, I am.
In this case, is this an appropriate moment to break and
Yes,
come back at 2 o'clock?
I'm grateful. Thank you.
Court rise, please.
Okay. No, I thought, I was going to lose really badly, the way it started. Yeah, but I guess I was going to write the judgment, and she's surely with you. Yeah.
As I think you should be.
Yeah.
Yeah, if you go over the two, we'll see where it goes.
Yeah.
And letters and all that.
So yeah,
Yeah, how much longer do you think it will be?
15 minutes.
Yeah. I think I just think 5-10 minutes.
After minutes to fly.
Just to deal with your pointing about ROB 16.1.
Yeah.
I think they've spotted it anyway.
Hmm?
I think they've spotted it anyway.
Yeah.
Do you think we should get the
Appendix.
what's it called?
Residence, probably, yeah.
I see what
I'll get it, yeah.
Yeah, the version that would reflect the time of the decision.
Will you be able to get it then?
I should be able to, yeah.
Yes.
If there's a problem, then we'll just get it.
Excellent. Thank you.
You said 2 o'clock, didn't you?
Hmm?
2 o'clock.
2 o'clock, yes.
Yes.